He didn't break a window. He didn't pick a lock. He didn't sneak through a back door or flash a weapon or raise his voice. He didn't even speak. He stood on a public sidewalk, pointed a camera at a building's front windows, and watched what happened next. What happened next was a bank employee sprinting outside to stop him, then another, then a board shoved in front of the glass every time he shifted position, then a 911 call, then multiple police officers, then handcuffs tightened hard enough to leave marks on his wrist, then the backseat of a police cruiser, then a trooper driving to the scene carrying a mobile fingerprint scanner, then a $1,000 cash bond, 44 minutes, dozens of people involved, a stack of legal theories that dissolved the moment anyone opened a law book. All because one man stood on public concrete and did something every pedestrian walking past that bank could do with their own two eyes. Look through the window. His name is Angel Moses. He runs a YouTube channel called Kansas City Accountability, and on May 14th, 2025, in Kirksville, Missouri, he didn't stumble into a confrontation by accident. He walked toward one, camera rolling, rights understood, silence loaded, to test whether the people sworn to uphold the Constitution actually know what's written in it. The answer arrived quickly, loudly, in handcuffs. The moment Moses raised his camera toward the large front windows of Equity Bank, employees came rushing outside. They planted themselves in front of the glass, demanded he stop, grabbed a physical board, and shoved it sideways every time Moses stepped to find a new angle. One called 911. Two managers came out. They stood directly in his line of sight, waved hands, gave instructions, and got nothing back. Moses said nothing, not one word. He just kept filming, steady and silent, while the panic around him built itself into a 911 call. Officers from the Kirksville Police Department arrived and, without independently verifying whether any law had actually been broken, sided with the bank on the spot. One officer told Moses flat out that filming through a window from a public sidewalk was an invasion of privacy. He even compared it to pointing a camera into someone's bedroom window. The problem is that is not what Missouri's invasion of privacy law says. Not even close. The statute under Section 565.252 of the Missouri Revised Statutes only applies to capturing images of someone who is nude or partially nude in a private setting, or filming under someone's clothing. A publicly visible bank lobby filled with clothed employees does not meet a single element of that offense. The officer's legal theory had no foundation. It was not a close call. It was not a gray area. It was simply wrong. Moses remained silent. The officers grew more frustrated. A sergeant decided that silence combined with continued filming was enough justification to physically detain him. Officers grabbed Moses, applied handcuffs tight enough to leave visible marks on his wrist, and placed him in the back of a locked police cruiser. Their position was that he was being detained, not arrested. Courts don't always accept that distinction when the level of force is disproportionate to the circumstances. The 1999 Missouri case of State v. Fleiter established that a seizure becomes a de facto arrest when the means of detention are more intrusive than reasonably necessary to achieve the investigative purpose. A man standing silently on a sidewalk, posing no physical threat and showing no signs of attempting to flee, placed in handcuffs and locked in a police vehicle, a court would have a serious argument to consider. Then came the search for a charge to justify everything that had already happened. Officers approached the bank employees and asked if they wanted to pursue peace disturbance. The employees agreed. That charge also had no foundation. Missouri's peace disturbance statute under Section 574 Toneds Odro 10 requires loud noise, fighting words, threatening a felony, actual physical fighting, or deliberately blocking pedestrian or vehicular traffic. Moses had produced none of those things. He had stood in complete silence on a sidewalk and pointed a camera at glass. Not one element of the statute was satisfied. Officers did not even have reasonable suspicion that the offense had occurred, let alone probable cause to support what was rapidly becoming an unlawful detention. With no identification produced and no name given, officers called for a trooper to drive to the scene with a mobile fingerprint scanner. Moses sat handcuffed in the back of the cruiser, had committed no crime, and was being held while the department waited for hardware to arrive. Two Supreme Court cases speak directly to what was happening inside that cruiser. In Florida v. Royer in 1983, the court held that an investigative detention must be temporary and last no longer than necessary to achieve the purpose of the stop. In Rodriguez v. United States in 2015, the court concluded that any extension of a stop beyond its lawful mission requires independent Fourth Amendment justification. Once the officer's own supervisor confirmed that Moses had broken no law, the mission was over. The handcuffs should have come off. They did not. A supervisor eventually reached the police chief, who looked up the applicable law and came back with a clear and unambiguous answer. Moses was on a public sidewalk filming a lobby that any member of the public could walk into freely. That is not restricted space. That is not private property. There was no crime. Let him go. One officer, relaying this to colleagues standing near the cruiser, admitted openly that he honestly would have thought peace disturbance would still work. Another confirmed what should have been obvious from the start. If a man is on the sidewalk recording, there is nothing we can do about that. A third suggested that if the bank didn't want people filming through their windows, they should put curtains up. These conversations happened more than 20 minutes after Moses was already in handcuffs. Just as he was finally being uncuffed and prepared for release, an officer pulled him aside. The fingerprint scan had returned a result. A bench warrant out of Lee Summit, Missouri, for failing to appear on a prior trespassing charge. Moses insisted his court date was June 26th and that he had been given incorrect information about the April date. It didn't matter. The warrant was active. Extradition was confirmed. Back into handcuffs, this time for something entirely unconnected to anything that had happened that morning outside Equity Bank. Moses posted $1,000 cash bond and walked out. He collected business cards from every officer on scene, demanded the call for service number, asked an officer to walk him across the street so nobody could accuse him of jaywalking, and announced he was heading directly to the Kirksville Police Department to file a formal complaint and request body camera footage. The officers who tried to explain themselves received a composed response and a promise that carried the weight of everything that had just occurred on that sidewalk. "This ain't going to be the last time you're seeing me." The officers earned an F. Not because the call was complicated or the law was ambiguous, but because it wasn't. A man standing on a public sidewalk filming a visible lobby is not committing a crime. Every statute they reached for required specific conduct that was never present. Instead of correcting the bank's misunderstanding and ending the encounter in 2 minutes, they escalated it into a 44-minute detention involving handcuffs, a locked cruiser, and a fingerprint scanner, all continuing well after their own supervisor told them no crime had occurred. Once that determination was made, the stop's mission was finished. Keeping Moses restrained while waiting to run his name for warrants was an unlawful prolongation of the seizure with no new articulable legal basis. Moses earned an A-. He knew his rights, stayed physically compliant at every moment of contact, and never broke a single law from start to finish. The only thing that cost him the full grade was his choice of total silence, which, while completely lawful and clearly intentional as a test of officer conduct, gave those officers the room to frame his behavior as suspicious and contributed to the escalation rather than deflating it. A single calm sentence early in the encounter might have ended everything before the handcuffs came out. But his conduct remained constitutionally protected throughout. He filmed from a traditional public forum. He didn't threaten anyone. He didn't obstruct anyone. He complied physically when force was applied rather than turning the encounter into a struggle. And he walked out with every officer's name, badge number, and business card. The Constitution didn't fail that day. The people sworn to uphold it just didn't know what it said. And by the time they figured it out, the marks were already on his wrist.